Okay, it is Monday, November the 4th, 2019, and as I reported to you 6 weeks ago, that you will get to week 6 very fast. We are here. Today is the start of week 6, and this is also your final lecture for this course. And I am going to take some time to provide you with some information and details that is beneficial to help you to complete the assignments for this module. Be aware of what I had previously stated, that any assignments that are from weeks 1 through 3 will not be accepted at this juncture unless we have had previous arrangements. I said 1 to 3. So therefore, 4, 5, and then of course 6, and if there are no extenuating circumstances, weeks 4 and 5, you will lose points. Week 6 assignments, of course, are due Sunday. Sunday. That is it. Sunday the 10th. And I'm going to share that with you. The quarter is over. Any assignments submitted after 11:59 p.m. Central Standard Time on after Sunday the 10th will be given zeros. So be aware of that. I don't care if they're perfect. I will do something in the system to ignore those assignments. So, and don't tell me I had some technical problems, because again, I'm letting you know well in advance what to expect. It is not my call. It is the policy that the school has set out, so that I am going to honor that, and I will help you, but I'm not going to violate the rules. So let's take a look at and share my screen with you for the final time for this course. And you see all this information here. I scroll down to the bottom, and you already know all of this. So let's go right down to first the written assignment for week 6. So week 6's assignment has to do with a topic that is kind of near and dear to me, the death penalty. And you're going to hear me talk about the death penalty. And you're going to recognize the fact that the death penalty is constitutional based upon the case of Furman versus Georgia, which I believe was a 1972 United States Supreme Court. That's F-U-R-M-A-N versus Georgia, G-E-O-R-G-I-A. And so in this written assignment, you're going to deal with the death penalty, and you're going to describe if the death penalty fits in the Constitution and answer if it is fair under the law. You're going to describe the current state of the death penalty in your state. In your state. And I will probably mention tonight the state of the death penalty in my state, which is Illinois. You're going to explain if you agree or disagree with the death penalty and why. And then you, of course, are going to satisfy the APA requirements, citations in the body, references at the end, Roman 12, cover page, and you're going to make sure that they're double spaced. And so I'm going to talk about that more specifically in a little bit. But this is what the rubric says that you need to do to get your 80 points. It doesn't tell you how long the paper has to be. We'll talk about that in just a few minutes. And then your final project focuses on the topic that you've selected in week 2 and elaborated on since that time. And what you're going to do is you're going to go through to get your 100 points, and you're going to focus on the aspect that you selected. You're going to offer your opinion of the law in your area, its current state, and what changes you would make, and if so, why. Include relevant case law and secondary resources. What are secondary resources? Articles, law reviews, magazines, and other sources. Include a recent related event or case. It says event, but event, E-V-E-N-T, or case. Include an interview from your local law professional. Make sure that you set that up in a separate area so I can know what you're doing with that when it comes to the interview, and make sure that you have citations concerning the person that you interview, and then you're going to meet the requirements, APA, again, citations and references, and so forth. And then you see here that this is your final lecture today, week 6. Your previous lectures are on this page as well. So let's go over and take a look at, again, what the announcement is telling you, where I reiterate what I said already. So in this week, we're going to talk about crime and punishment. And, excuse me, and so you were to read chapters 12 and 13 of your textbook, Constitutional Law, and discuss or deal with the activity cruel and usual punishment, which we will talk about today. And then your discussion assignment, DNA evidence. Of course, your initial post is due, Saturday, and then your reply post is due Sunday the 10th. And you know my parameters and rules at this point about those posts. Finally, complete the written assignment, death penalty, which I just talked about, and I'm going to elaborate again in a few minutes. The Fourth Amendment final project, which I've elaborated on, and then you have the final exam, which is timed. And they're due this Sunday, November 10th, 2019 at 11:59 p.m. Central Standard Time. Remember, follow the rubric for your written assignments. And then there's a reminder again that the quarter officially ends November 10th, 2019, and then I encourage you to take the time to complete the end of quarter student evaluations that you've received in your email. I will be completing your grading for week 5 by Friday, as I have been, which they are due to be given to you. So you'll have them. Some of I've already started grading already. And then let's take a look at your course calendar. So you'll see again, my students have no excuse for deadlines because I reiterate over and over and over again. Okay, so let's go to November. Okay, which we are there, but let's go to, okay, here we are, November the 2nd, which is today, your live lecture today at 8:30, no, yeah. Oh, no wonder, I'm looking at the wrong one. Let me take that out. Sorry about that, my bad. Let's take that out. Now let's see your course calendar, which shouldn't be in December. There we go. So this is where we are. So for the 4th, for your live lecture, which is today, your reading assignment, your initial post, and then your reply post. I said it was due Sunday. My bad. I correct myself. Your initial post is still due on, your reply post is still due on Saturday the 9th. That's a correction, not Sunday. If you submit it Sunday, it's going to be late. However, your written assignment and your keyword, as well as the final exam, are all due on the 10th. Absolutely no exceptions. And it tells you in here that the quarter ends. I already told you that. So there it is again. So don't come to me and say, oh, I thought, no. The last assignments are due on the 10th for this week 6, okay? And any other assignments that you turn in. So now let's go right into our topic. Let's again spend some time going over the assignments. So I already told you the parameters of the final project. I told you when it is due, and it tells you to incorporate the feedback that I have submitted to you in your previous weeks. So that would be 2, 3, 4, and 5, and then you're going to satisfy these things. Now, here's the length: 6 to 8 pages. You will lose points if you don't have 6 pages. And use APA guidelines for citation. And when you do cite cases, remember, I've already shared with you before, please include the full court citations, and I've demonstrated to you how to do that. And then include all the elements that it's asking, which are the same things here. So now the thing that's added that you did not know from the rubric is the length of the paper. 6 to 8 pages, not single space, double space, double space. All right? All right. So, and then, of course, if you click on it, you see the date it is due, which is Sunday, the 10th, to get your 100 points. That's it for that. Then your written assignment, the death penalty, in a 1 to 2 page paper, answer the following. And I already went over these bullet points because they are the same ones that are in the rubric. So 1 to 2 pages. Now remember, you run your papers through Grammarly, because if you have a percentage higher than 25, you're going to lose those points. So you're going to lose that number of points on your grade. And I will be reporting it to the school, because at this juncture, especially since you are in the Bachelor Completer program, you should be well aware of how to put critical thinking in your papers and be able to deal with each of these issues appropriately. Okay? And then your discussion assignment, DNA. You know, I have said this many times that DNA is the most revolutionary, to me, technological thing that happened. People use body cams, they'll use the fingerprinting system now, but the DNA changed the course of criminal investigations, both for the prosecution and for the defense. When I first started out as a lawyer in 1978 practicing and concentrating in criminal law, and then later on getting involved in law enforcement for about 4 years as a police officer, 89 to 93. DNA wasn't a big ticket then, but now DNA is used to identify people. It's also used to solve crimes. It is also used to exonerate individuals who are charged with crime in wrongful conviction programs. My alma mater, Northwestern University School of Law, has a wrongful conviction program and has been successful in exonerating many individuals because the DNA evidence did not match. The very first case that I recall that they had was a young man by the name of Rolando Cruz, who they had tried him in DuPage County in Wheaton, Illinois, found him guilty of murdering a young girl by the name of, I think her name was Janine Nicarico. At any rate, it was discovered through DNA evidence that he did not rape and murder that young girl, but that a guy who was already incarcerated by the name of Brian Dugan. And you can do some research and you'll see that. But be aware of the fact that DNA has revolutionized the criminal justice system. And so take a look at these 2 cases where individuals were exonerated, and make sure that you apply them in terms of dealing with your initial posts and reply posts. And, you know, I can tell you this much. One of the faults with DNA is just like anything else. If it's not handled properly, if it's not preserved properly, it's not going to be beneficial. But again, when it is properly preserved and used in a criminal case, it is a great tool for prosecution, law enforcement, and defense attorneys. So your discussion topic is the DNA evidence, dealing with these two cases here, Juan Rivera and Jerry Hobbs. The final exam is a comprehensive exam. It's a 60-minute exam. You'll have one opportunity to complete it. It consists, it's not really that long, 19 multiple choice and true-false questions and 6 short answer questions. What that means is that I will have to manually go in and read those 6 short answer questions in order for you to get your final grade. And I will look at the elements to see if you satisfied the questions completely, and if you have, you will get those points for those 6 short answered questions. If not, you'll lose points for that. Remember, when you take that exam, you agree to abide by the academic misconduct policy, which means that you will not have textbooks, you will not have stickies or notes or anything like that. You won't be on the phone with anybody. You're going to take the test, basically a closed book test. You're on your honor. But remember one thing, you got to make sure that you operate in integrity. I've started that with the week 1 open house, and I maintain that criminal justice professionals need to operate ethically and professionally. And this is your opportunity to demonstrate that as a student in terms of taking these tests. So that's your final exam. And then your live lecture, I will give you a keyword at the end. And those are your assignments for the week. If you have questions, reach out to me. At this juncture, I would recommend highly that you don't email me, that you do text me and or call me if you have questions. You have access to me as a student I shared recently that said that they don't have much access to the professors. I said, you're not talking about me, because my rule is, you know, any hour of the day except the 25th hour of the day, and I'm here to be of support to you guys. And I do respond very quickly because I want to help you achieve student success. All right, so now that's it for the assignments. So now let's spend the rest of the time in this final lecture with me talking about the 8th Amendment and issues concerning bail, when it is ordered, and then we're going to discuss the death penalty and due process of law. All right, so we're going to deal with, first of all, let's deal with the 8th Amendment. And so we go down here, and the 8th Amendment is very simple. As we deal with the case of Miller versus Alabama, a 2012 case, in which the Supreme Court raised issues pertaining to the 8th Amendment. And you can click on this, and it tells you what the 8th Amendment says. We're transferring to it right now, and there it is. There it is right there, explaining, accept that. I have to accept that. Okay. So now, the 8th Amendment to the Constitution here it is right here, quoted right here in front of you. And it explains that, and let's see, I had it a second. I think I left it, took it out. Let's go back. I had it. Let me take you back to it. Okay. Eighth Amendment reads, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. That's the Eighth Amendment. That's the Eighth Amendment itself. All right? So in the context of talking about this, in this Eighth Amendment case, it asked the question about a minor sentenced to life without parole for murder. And the question is, does this violate the cruel and unusual punishment clause of the Eighth Amendment that I just read to you? And two cases from the United States Supreme Court make it very clear that minors should not be treated like adults in sentencing. In the famous case, the landmark case of Roper versus Simmons in 2005, the Supreme Court once and for all settled the question of whether or not minors could be subjected to the death penalty. The Supreme Court made it very clear that because of the age of those individuals and because of the goal of what the courts say that we should be doing with minors, that individuals under the age of 18 should not be sentenced to the death penalty, no matter how heinous the crime is. Excuse me. Prior to that, there were some states who had that, but there was a split in the states, and finally this case solved it once and for all. Says it is cruel and unusual punishment to subject minors to the death penalty, period. And this is for jurisdictions that have the death penalty. And so then, after that, in 2010, in Graham versus Florida, the Supreme Court said that it is unconstitutional and a violation to sentence a minor to life without parole to crimes other than murder. So here's the point. In order for a juvenile who cannot get the death penalty to be sentenced to life without parole, the crime has to be murder. And that's what Graham versus Florida stands for. And the reasons that it says is because the age and diminished capacity of young people prevent them from having much moral capacity, culpability as adults have. Now, I already know what you're thinking, yes, but the Supreme Court has spoken on it, and that's the law, and we have to accept it. And that we can rehabilitate minors better than we can do adults. That's the belief, and that's the goal of the juvenile court anyway, to deal with minors. So, making it quite clear, the Eighth Amendment in terms of dealing with that. Now, I'm going to tell you that when we start talking about the death penalty, as I said earlier, there was a challenge in the Supreme Court that took place, and I'm 99.9% sure, I'm doing it from memory, so let me check something on my phone here, but I'm pretty sure I'm right, that Furman versus Georgia, the United States Supreme Court ruled at 408 U.S. 238, 1972. It was a criminal case in which the United States Supreme Court struck down all death penalty schemes in a 5-4 decision. Now, what that really meant is that they did not say that the death penalty was cruel and unusual punishment, but what happened is that it was determined that before the death penalty can be given to adults, that they had what we call a bifurcated hearing. Number one, that if you were found guilty and the crime based on the jurisdiction in which you committed the crime and were tried under had a death penalty, then the jury or the judge would determine whether or not, with mitigating and aggravating circumstances being presented, whether or not you merited the death penalty. And that's pretty much what that case stood for. Now, it was a 5-4 decision. And what that means in the vernacular for us as lawyers and educators of political science, as I was both of them, is that you can recognize that one vote can change the decision in the future. But as I speak to you right now, this Monday, November 4th, 2019, Furman v. Georgia is still good law. And you can do some research on that. Furman versus Georgia. Now, you should also be aware that there are jurisdictions that don't have the death penalty, and you have that assignment to look that up in terms of your written assignment. Let me say to you that in Illinois, give you a little history to help you understand, because that's the state I practiced in, and those of you who are Illinois students are getting an advantage because of this, is that my firsthand legal experience is that the First Amendment, that the death penalty did exist until, I believe it was 2000 and, let me see, the death penalty was done away with. Let's see, give me a second, bear with me. Okay, here we go. We had the death penalty in Illinois until 2011. Until 2011, and it had been in existence from way back in 1928. So the last execution in Illinois took place in 2000, and then the governor at that time, a guy by the name of George Ryan, declared a moratorium on executions, and then a decade later, on March 9, 2011, then Governor Pat Quinn, who I knew dearly because Pat was one of my classmates in law school. In fact, I was assigned to help him to break into law school. Pat was in the class of 1980 at Northwestern University School of Law. I was in the class of 78, and so Pat was one of the students that I was like the big brother to. And so when Pat became governor, he, based upon what they had seen, that there were many problems with the death penalty. In other words, the deal is this, is that there were, if one person who was later deemed to be innocent was executed, that's a bad thing. So therefore, because there were many flaws in the death penalty and how it was being meted out, it was determined by Governor Ryan that there was a moratorium on executions. Now, what happened is those who were on death row in Illinois at that time were then placed in life, and then it was determined later if they were exonerated, then of course they were released. So, but finally in 2011, March 9th, Governor Pat Quinn permanently abolished the death penalty in Illinois, and we haven't had that since that time. All right, so so you should be aware of that. Now, I will tell you this, a little history about the death penalty is that when Furman versus Georgia in 1972 was issued, it was struck down at that time because of the way it was structured. So it didn't mean the death penalty was a violation of the Eighth Amendment. It meant the way it was currently structured. And so it was reinstated in 1974, but voided by the Supreme Court in 1975. And then in 2018, Governor Rauner made calls for the death penalty to be imposed on convicted cop killers, but it didn't happen. So, so bottom line is, at this stage, there is no death penalty in Illinois. Now, My personal position regarding the death penalty, which many of you probably would feel that based upon your knowing my experience and what I went through with my parents being killed, that I would believe that the death penalty would be something that I'd be in favor of. But to many of my students' surprise, I say no, I am not, and I'll explain why. The individual who killed my parents, as I shared many times, I had a chance to see that individual after he had served his 3.5 years in 1972, I believe it was. I had a chance to see him on the streets. The guy was gone. His mind was gone. He was like the Walking Dead. And he was talking to me. I didn't realize it was me. I hadn't changed that much, but his mind was gone. He was just lost. And so I determined that when you take a person and sentence them to life without the possibility of parole, they will then live every day as if they're in a death row situation, because their minds will be gone, and that's punishment better than taking them and executing them, because when you execute them, then you take them out of their misery. That's my position on it. I don't believe in the eye for an eye. I believe that, again, they will suffer more by living than being executed and put out of their misery. So that's what I wanted to say about the Eighth Amendment. Now, the other thing that I want to say about the Eighth Amendment relates to reasonable bail. A lot of people should be aware of the fact that the Constitution does not guarantee bail, but guarantees that bail should be reasonable and commensurate with the crime that's committed. In other words, the more severe the offense, the higher the bail, and that for some capital crimes, such as murder in some instances, bond is not granted, and it's because of the circumstances. And you got to remember the purpose for bond and bail is to guarantee the individual's appearance, and then two, that person would not be a threat being released. And so there are times when, as for example, in the organized crime cases where individuals are not granted bail because of the possible repercussion for witnesses that would participate in the trial itself. So the bottom line is that the Eighth Amendment does not guarantee bail, but guarantees the bail must be reasonable under the circumstances. And that's pretty much what I want to say about the Eighth Amendment. All right. So now let's move on and let's talk about DNA. DNA. I already kind of talked about it quite a bit, but and it talks about beyond the fact that the death penalty seems to be cruel and unusual punishment to many people, there's facts that DNA evidence has determined that individuals facing death or life sentences really were the wrong people. And you'll have a chance to determine that from your discussion posts dealing with these two cases here. The case of Juan Rivera as a match in a case in which the prosecutors, they would not dismiss the charges against Juan Rivera, and he was convicted on 3 counts on 3 occasions. But then the appellate court reversed and dismissed the case outright, and Juan got to walk as a free man. And the basis for it, when you read that, you'll discover is that the DNA evidence that was properly gathered made it possible to determine that he was not possibly the one who should have been convicted and someone else. Like the Brian Dugan situation, like the Juan Rolando Cruz case that I mentioned earlier that Northwest University participated in, and many other cases. And so these are coming up. So you're going to take a look at this case. The next case you're going to take a look at is Jerry Hobbs. And he had sat in the jail for 5 years, okay? He was in jail for 5 years, and when he was in that jail, he was sentenced for murder and rape. Now, DNA evidence exonerated him, but the prosecutors still would not dismiss the case right away. And that happens. That happens. I'll talk about that in a minute. Finally, the public defender's office did some more detailed work, and that's why I tell people the public defenders are also very good lawyers. And he was released, and the actual killer was actually caught. And this case led to the prosecutor's office to be fired because the lead prosecutor refused to consider the inevitable. And here's what I'm getting ready to say. There are many people who still will not accept that when DNA evidence exonerates someone, that person didn't do it. It's a scientific issue. It's just like your fingerprints and those kinds of things, that everyone has individual, and your DNA. And you guys are pretty much familiar with DNA. You've heard of DNA ancestry, where now people are able to go and get these kits, and they're able to determine who some of their family people are, and it matches them up based upon, and they utilize the saliva. And the secretions from the body, the blood, the urine, the saliva, and the sweat of individuals, all are ways that DNA is gathered, and it leads to who that person is. I know of a case that was solved here in Illinois. It's called the Brown's Chicken Massacre, which happened in a place called Palatine, Illinois, some years ago. And if you Google it, you'll see what I'm talking about. Well, some people murdered and killed workers, put them in the refrigerators. And for years and years and years, that crime was not solved. But then finally, somebody started talking about it, and then they had preserved as evidence from the scene a piece of chicken that had been bitten into. And because that was preserved properly, they were able to perform DNA tests on it, and it matched up an individual who was later on convicted of the crime. So it's a good tool, and it works. It's just using scientific evidence, but it's just like anything else. It has to be gathered properly in order to be of benefit. And so that's a deal. So I also know of a attorney, young man that I've never met face to face, but we've talked on the phone, who was convicted of rape in Wisconsin, and his name is let's see, he's my friend on Facebook. I think his name is Jared, but he's an attorney. He went to law school, and I'm trying to say Jared, G-A-R-R, Jared M. Adams is his name. And this young man committed his life after that, went to law school, got his record cleared, got his name cleared because of that DNA, and now he has a wrongful conviction practice that he operates out of New York. So it's Jared, J-A-R-R-E-T-T M. Adams, and Jared is a young man who is an example who took the DNA evidence and turned it into, I'm trying to get you some more, Jared Adams. Here we go. And there's a story. You could go and you could find it. He was wrongfully convicted of sexual assault at age 17 and sentenced to 28 years in a maximum security prison in Wisconsin. After serving nearly 10 years, he filed multiple appeals. He was exonerated with the assistance of the Wisconsin Innocence Project. And you could go through and you could find his name, and you can check his organization. There's a lot of YouTube information. And as I said again, he was interviewed on NBC, and he is a advocate who deals with wrongful convictions. And he has, like I said, he has his law offices in New York City on 40 Fulton Street, floor 23 in New York. And so he specializes in terms of dealing with that. So I'm saying here's a young man who took advantage of that. So I wanted to share that with you. So that's what I want to talk about, DNA evidence and exonerations. I am totally in favor of those because innocent people do sit in prison and jails, believe it or not. I can tell you, again, the DNA we welcomed. So now let's conclude by talking about the 14th Amendment of the United States Constitution. Now, what the 14th Amendment says is that, I'll read it right here, it says all persons born or naturalized in the United States and subject to the jurisdiction are citizens of the United States and the state where they reside. No state shall make or enforce any law that abridge the privileges of immunities of citizens of the United States, nor shall any state deprive persons of life, liberty, or property without due process of law, nor deny any person who is in this jurisdiction the equal protection of the laws. So the due process clause, what it does is it means that individuals should not have things taken away from them, including their liberty, or incarcerated, or held captive without having the procedural processes of a right to a fair trial, the right to face their accusers, and produce evidence of their innocence. And so the 14th Amendment, in the way it applies in the due process clause of states, is some examples here. It says if a defendant pleads guilty to burglary and the criminal damage to property is charged is dismissed as part of the plea, a year later the prosecutor decides to charge the defendant with the same crime that was dismissed. Under due process, the state cannot prosecute this charge. This would not be double jeopardy because jeopardy never attached since the case was dismissed. So it never went to trial. If it did, and then they tried to do it, then that's double jeopardy. But what they're saying is that the state had a chance to bring the charges, and they dismissed the charges instead, and they cannot prosecute that individual on that charge again. Secondly, laws must be defined and clear and not void, and that's what we call void for vagueness. Such as, for example, many of the laws that existed in many jurisdictions concerning what we call loitering that were used to try to reach gangs for gathering at points were considered as vague because what was considered as those gatherings were subjective, and so everybody had their own opinions about what it was. The law can't operate like that. It has to be objective, and it has to be such so that it's clear that that individual is on notice what they're doing wrong, so that the violation must be very, very, very clear. And so you want to make sure that you understand the 14th Amendment and how it relates to criminal law and procedure. And No property can be taken away, and that happens in civil cases as well as in criminal cases without due process of law. The opportunity to provide a defense. Okay, and so that's pretty much what I wanted to share with you today. And I want to say to you, I hope that you've enjoyed this class. I hope that you've learned a lot about the Fourth Amendment and the exceptions to the Fourth Amendment, and that your projects have helped you to become clearer on understanding how those things apply. And I hope that you will continue your education. I hope that you will ultimately become criminal justice professionals. As I like to say all the time, remember, I'm here. I've worked with many students who have completed my classes and gone on to graduate. I've helped them with letters of recommendation, made phone calls, and things of that nature where they're going further in their education. There have been a few who decided to take me up on after criminal justice courses to go to law school. I constantly work with students. I'm working with one right now. I worked with several in the past and help them to navigate the challenges which law school offers. And I always tell people, don't get discouraged because, excuse me, because if I did it, I believe anybody else can do it, and you have to be confident in what it is. And my role as a professor is to encourage rather than to discourage students from achieving success in their careers. And so I'm going to leave you at this time with this phrase, due process. That's what I want you to give me to get your final points. Remember, that phrase will be due by this Sunday the 10th, and you know how you have to put it. If it's after that, you're not gonna get any points. And so, again, I wish you the best, and feel free, like I said, to reach out to me if you have any questions about anything concerning this course that you are not clear upon. And as I said earlier, I do recommend that you call me or text me on my phone, which you have the number, 630-660-8480. It's right here, sitting right here in front of me here, and I will respond oftentimes with a text, with a phone call, because I'd rather talk, because sometimes emails and texts, there's a lot of confusion, and you miss a lot. And so that's about it. So I'm going to say good night to you.